Okay, hi everybody. I think we've sort of let everybody in at this point and we can go ahead and get started. My name is Maureen St. Cyr. I am the relatively new Executive Director of the Mass Fair Housing Center, and I will be the moderator for this panel. I am really excited about this panel. I'm looking forward to a robust conversation about various issues relating to voucher discrimination. As you know, is true many places in the country right now, Massachusetts has been experiencing a housing crisis that has really made things challenging for folks with vouchers, which are intended to be sort of a tool to enable folks to access affordable housing, housing stability, and to address issues relating to segregation. But even in states like Massachusetts, which is one of the probably about less than half of states in the country that do prohibit discrimination based on voucher status, there are really high levels of discrimination that people with vouchers face. One study from Suffolk University found that testers experienced or there was evidence of discrimination in about 86% of tests done, which is really quite high. And frequently the discrimination looked like the housing provider stopping all communication with the voucher holder after learning that the person had a voucher. So not even getting to the point where that person could see a unit, right? So when we're talking about a person with a voucher having to contact significantly more apartments before they can even see one, and then you layer on top of that the challenges posed by the current housing and affordability crisis, the path from receiving a voucher to actually being able to utilize it is a really difficult one right now. And like I said, that's in Massachusetts, right? That's what we're experiencing here in Massachusetts, one of the states that does prohibit voucher discrimination. So here on this panel today to talk about the sort of scope of the challenges that people are facing, as well as the protections here and the ways that we've tried to address voucher discrimination. We have four folks. We have Sophia Stavrocky, who is the Snowmass coordinator for Massachusetts Department of Housing and Community Development. And she's going to provide background on the voucher program and our Snowmass program, which is a mobility program and stands for Supporting Neighborhood Opportunity in Massachusetts. We have John Burke, who is an Assistant Attorney General in the Civil Rights Division of the Attorney General's office here in Massachusetts. And he will discuss the role of the Attorney General's office in enforcing fair housing protections that exist here, including or focusing on voucher discrimination. We have Jane Edmonstone, who is the Senior Supervising Attorney for the Fair Housing Unit at Community Legal Aid, which is the civil legal services provider for Central and Western Massachusetts. And she will discuss a new initiative that Massachusetts fair housing organizations have in place right now to address voucher discrimination. And then finally, we have Todd Kaplan, who is a senior attorney in the Consumer Rights Unit at Greater Boston Legal Services. And he will discuss GBLS's current federal court case challenging tenant screening policies that affect voucher holders' ability to access stable housing. We will have a question and answer period at the end, and I will be monitoring the chat throughout. So if you have questions for the panelists, feel free to either hold them to the end and put them in the chat then, or if you put them in the chat, I will do, throughout, I will do my absolute best to not sort of lose them and keep track of all of them to be able to pose them at the end. But with that, I will turn things over to Sophia to start our presentation.
Hello, everyone. Thank you so much for having me here today. It's been a pleasure and an honor. Give me 1 second so I can share my screen. I prepared for you today a very quick PowerPoint presentation. So just one moment. And I hope everyone can see my PowerPoint presentation. Let me just do this. Okay, now it looks a little better, right? Thank you all. My name is Sofia Stavraki. I am the Supporting Neighborhood Opportunity in Massachusetts Coordinator for the Division of Rental Assistance at the Department of Housing and Community Development. And today we are going to be talking a little bit about the Housing Choice Voucher Program, the Housing Mobility Program, SNOMAS, and some of the challenges participants are facing, especially with housing discrimination. But let me start with DHCD first. DHCD, the Department of Housing and Community Development, oversees combined resources of nearly $1 billion to help households in Massachusetts live affordably and safely. Some of the activities include funding affordable housing development, overseeing over 43,000 units of state-funded public housing, overseeing emergency shelter for families and individuals, and providing resources for municipalities and planning agencies. DHCD's Division of Rental Assistance administers rental subsidy programs such as the Massachusetts Rental Voucher Program, or MRVP, and the Housing Choice Voucher Program, also known as Section 8. The Housing Choice Voucher Program, or Section 8, increases affordable housing choices for very low-income households by helping families pay a portion of their rent in privately owned housing. Our Housing Choice Voucher Program currently serves over 20,000 households and is administered by 9 regional administering agencies, or RAAs. DHCD is also a designated Moving to Work Housing Authority, meaning it has the opportunity to design and test innovative programs and policies. In our next slide, we see DHCD's regional administering agencies per area. As you see, they're color coordinated for the areas they cover. But what is SNOMAS? SNOMAS is a program that DHCD initially piloted starting back in the summer of 2019 in 2 regions of the state. Then, in October of 2020, we expanded it to be statewide. SNOMAS is specifically for families with children who have housing choice vouchers through one of our RAAs, which we saw on the previous slide. And the goal is to help those families move to communities with high quality schools, parks and open space, and healthy, safe environments. We're trying to ensure that families can really take advantage of the choice that is embedded in the Housing Choice Voucher Program. And we see this program as providing valuable benefits to voucher holders and property owners alike. And the next question is why it is important? Well, neighborhood matters. We know from an abundance of research that a neighborhood a child grows up has major impact on his or her outcomes later in life, and that the earlier in their childhood they move to a better neighborhood, the bigger impact they will have on their long-term outcomes. Also, diversity benefits everyone. Helping the families and children we serve move to higher opportunity neighborhoods not only benefits them, but it also benefits the families and children that they are already living in that neighborhood. Research shows that all students benefit from attending racially and economically diverse schools where they are exposed to peers of different backgrounds. They tend to become more open-minded, less biased, and better prepared for the real world. Finally, families with vouchers face a lot of barriers. Despite the good reasons of moving to high opportunity neighborhoods, and even though housing choice vouchers can be theoretically used in any community, voucher holders face significant barriers that limit their choices, and as a result, they tend to be concentrated in high poverty neighborhoods. Only 8% of DHCD's voucher holders with children currently live in high opportunity neighborhoods. So our goal is to help remove some of those barriers and give our voucher holders more options where to live. We will talk in a few minutes about some of the specifics of the program, but first, let me tell you and explain how we determined which neighborhoods would be designated as high opportunity. We recognize that there are so many different ways we can rank neighborhoods and so many different factors that we can take into consideration. The fact that some neighborhoods are not designated SNOMAS areas does not mean that there's anything wrong with them. We just wanted to try to highlight communities that seem to be particularly good places for children to grow up based on the data that is available. And we decided to use Brandeis University's Child Opportunity Index for a few different reasons. First, it's quite comprehensive. It takes into account 29 different education, health, environmental, and socioeconomic factors. Second, the Child Opportunity Index is based on census tract rather than the city or town. The research suggests that it's not just the town you grow up, but the specific neighborhood. So drilling down to the census tract level makes us more confident that we are helping families move to areas that will have a biggest positive impact for children. Lastly, since SNOMAS is a statewide program and this index has been calculated for every census tract in Massachusetts, it enables us to compare apples to apples across regions. In other words, a high opportunity neighborhood in one part of Massachusetts is on par with another high opportunity neighborhood in another part of Massachusetts. So how can we determine whether rental properties are located in a SNOMAS opportunity area? We have developed the SNOMAS address locator tool, and this is available both to voucher holders and property owners to check if an available rental is located in an opportunity area. As you see, the only thing required to do is to enter the address of a particular property, and the tool will tell you if it is in an opportunity area, along with some other helpful information, including the SNOMAS payment standard for that neighborhood. And we will talk more about the payment standard in a few minutes. But let me switch gears to what does SNOMAS offers to voucher holders. As I mentioned earlier, we're trying to tackle some of the common barriers that may have prevented voucher holders from moving to higher opportunity areas in the past. So each family will have an assigned dedicated mobility specialist who will work closely and support the family before, during, and after the move. We think that extra level of support from a staff person can make a big difference when a family is looking to successfully move to an opportunity area. All SNOMAS participants complete a series of required counseling trainings during which they are asked about their housing history, income, credit, and other factors that may impact their housing search. Participants, with potential barriers to finding or retaining a unit are referred to resources and services to help address these barriers. But the participants also continue to receive counseling after they move into a unit. SNOMAS also provides families with detailed information about different communities and one-on-one assistance finding housing. So the staff take the time to get to know each family and figure out what they're looking for and help them think through which communities might be a good fit. Our hope is that families will take their time and review all possibilities so that they move to a neighborhood that they want to be long-term. We also know that some families are hesitant to relocate because moving can be such an expensive process. SNOMAS provides participants with financial assistance that can be used to cover moving costs, including security deposit, moving truck, as well as expenses that might come up after the move. And last but not least, SNOMAS offers a higher voucher value in certain communities. As you know, DHCD establishes its Section 8 approved payment standards, which are basically represent the maximum voucher of the, maximum value of the voucher every year. The payment standards are set at the regional level, and this year they are set at 120% of HUD's fair market rents. With Snowmass, we've tried to take a more nuanced approach. We look at the small area fair market rents set by HUD and also set at the zip code level. And if those are higher than the regular DHCD payment standards in a particular opportunity area, then we will use those as a payment standard. Our hope is that this will expand the number of potential units in opportunity areas, since we are able to use that payment standard. But before I transition, one question that comes to mind is, what else Snowmass offers? Snowmass also offers to landlords. And let's look at what landlords that participate in the program can get out of this. First of all, they can get up to $1,800. Typically, this is done in 2 installments, $1,200 when renting to a Snowmass participant, and then an additional $600 when renewing the lease or renting the unit to another Snowmass tenant, a potentially higher rent subsidy. And this is compared to other local housing authorities. And of course, it does depend on the community. As we said, Snowmass has the flexibility to utilize either the small area fair market rents or the DHCD payment standards, whichever is higher. Also, expedited inspections and processing of paperwork and single point of contact at each RAA. The single point of contact will help ensure a smooth, expedited lease-up process and handle any inquiries after the tenant moves in. However, voucher holders often mention difficulty finding units, which makes housing search challenging and frustrating because of voucher discrimination they may experience. In the next slide, we will see some of the examples Snowmass participants have mentioned during their conversations with mobility specialists. So here are some examples of the challenges our Snowmass participants face during their housing search. Rental listings that state no Section 8, or oftentimes this is not a Section 8 unit. Required non-refundable holding fees for some of the rental listings that prevent participants from proceeding with their application process if not paid upfront. Landlords stating they don't want to deal with a required inspection or paperwork, or even work with the housing authority. Rental listings that require the tenant's income to be X times the rental amount. And landlords denying renting to families with children under the age of 6 because of lead paid in the unit. And these are just some of the most common challenges we often hear. I'm sure there are more. Some of these challenges may result to no further communication with interested participants. For example, a landlord may say, we will follow up with you, and then there's no follow-up, or the unit is no longer available, or even change the attitude once participants mention they have a housing choice voucher that may include increased numbers of questions pertaining to participants' housing history, ability to pay rent, or other bills oftentimes. So it becomes a little more intense. With that, I will conclude my presentation. And before I hand it off to Jonathan Burke, let me share if you have any information, any general question, any general questions about the program, feel free to reach out. This is my contact information, and happy to also share it via chat. Thank you all so much.
All right then. So again, I'm John Burke. I'm an Assistant Attorney General in the Massachusetts Attorney General's office. So I'm going to talk a little first about just exactly what the protections are under Massachusetts law for voucher discrimination. And then I'm going to go over the Attorney General's role in enforcing those laws. So I think generally we can say that under Massachusetts fair housing laws, any form of discrimination against any person who receives any federal, state, or local housing subsidy or any other form of public assistance is prohibited. And discrimination there, as you were just hearing, covers a lot of different types of activities. Generally, you can think of it as meaning any conduct or any attempt to treat someone differently or unfairly because they receive a housing subsidy, a voucher, or because of any requirements associated with that subsidy program. And so, we see this occur in a number of ways. Some of the most common are, just a flat out refusal to rent to Section 8 tenants. You can't do that. Usually this is a result of unfair and inaccurate assumptions that people who receive housing subsidies will somehow be worse tenants. And so this covers both a flat outright refusal. You can't run ads that say we don't accept Section 8 tenants. You can't tell applicants that we don't accept subsidy recipients or voucher holders. But you also can't do things like refuse to call people back or ghost them or treat them differently once they disclose that they receive a voucher. You also can't make any statement of a discriminatory preference. And what that means is, just like you can't tell people I won't rent to people who receive a housing voucher, you can't say I would prefer to rent to somebody who doesn't receive a housing voucher. You can't run ads that suggest that you would prefer to rent to somebody who doesn't receive a housing voucher. And landlords can't do things that are more subtle, like tell their real estate agent that they would like the person to find a tenant who doesn't receive a housing voucher, or that they're willing to offer some sort of inducement to tenants who don't have housing vouchers that they're not willing to give to tenants who do have housing vouchers. Similarly, you can't refuse to rent to a tenant because of the requirements of the subsidy program. So you can't refuse to rent just because you don't like a subsidized tenant, but you also can't refuse to rent because you don't like the requirements that go along with that program. So most subsidy programs, most vouchers come with requirements related to what has to be in a lease. Most require property inspections. And we hear from a lot of landlords that tell us that they don't have any problem with subsidized tenants. They just think that the requirements that are associated with renting to subsidized tenants are burdensome and expensive, inconvenient, whatever that may be. All of those justifications are off the table in Massachusetts. They're not legitimate reasons to refuse to rent to somebody. Additionally, you can impose conditions on subsidized applicants that make it harder or less desirable for them to rent an apartment. So this is things like requiring tenants who have a voucher to go through additional screening, limiting their access to amenities at the property. So if you have a larger scale landlord who has a gym or something like that on property, you can't limit access to that. You can't require that rent be paid in different ways. We've seen a number of cases come up in recent years where landlords were trying to get tenants who had housing vouchers to pay rent by certified check, again, based on the sort of inaccurate and unfair assumption that they would be less reliable rent payers. You also can't apply what seem to be neutral policies to subsidized tenants, to voucher holders, if those policies operate to either exclude the voucher holders or to make it unfairly difficult for them to rent an apartment. And so when I say neutral policies here, I mean policies that on their face apply to everyone, right? So anyone who wants to apply to rent an apartment at a property, things like requirements that applications be completed within a certain time period, or that apartments will only be held off the market to allow somebody to rent them for a certain period of time. So like we've talked about, most subsidy programs, most voucher programs have time standards that go along with them. There are an amount of time that the subsidy provider has to complete a lease, to complete a property inspection and things like that. And so rules that require leases to be completed in a shorter period of time could operate to exclude tenants who have vouchers or make it nearly impossible for them to rent apartments there. And those things are discriminatory under Massachusetts law. Similarly, minimum income requirements or minimum income to rent ratios operate the same way. If it's impossible for a subsidized tenant to meet those standards, or if it's very difficult and it operates to unfairly exclude them, the fact that those policies may be applied to everybody doesn't change the fact that they have an unfair impact on subsidized tenants who receive vouchers, and they're not allowed under Massachusetts law. So if you are a voucher holder or you administer vouchers and you experience any of this type of conduct, the law gives you several different options on how to handle it. You can file a complaint with the Massachusetts Commission Against Discrimination, Boston Fair Housing, or a number of the other administrative agencies. You can file your own court case, or you can file a complaint with the Attorney General's office. So in Massachusetts, the Attorney General's office has the authority to investigate and civilly prosecute violations of the fair housing laws and the anti-discrimination laws. And what that means is that the person who is the victim of the discrimination does not have to participate in the prosecution. These are enforcement actions that the Attorney General's office brings on behalf of the Commonwealth. And so there are different requirements for how those are handled, but that's a big difference in Massachusetts as opposed to some other states. And so, just a little more information about how the Attorney General handles these. I think the first thing is that dealing with voucher discrimination is a strategic priority for us. If it's happening, we want to hear about it. In addition to receiving, complaints from individuals who have been victims of housing discrimination, we work with public housing authorities, we work with other government agencies, we work with advocacy organizations to actively identify landlords who are engaged in discriminatory or problematic behavior. And we do bring these cases, and we've brought them in increasing numbers in recent years. And the penalties can be quite severe for landlords that do engage in this type of conduct. It can involve fines, civil fines and damages that run well into the tens of thousands or hundreds of thousands of dollars. And it can involve some monitoring and continuing monitoring by the government to make sure that the discriminatory behavior isn't repeated. And I think there I will pass it off to Jane.
Thanks, John. Good afternoon, everyone. For those of you that weren't here right at the beginning, I work at Community Legal Aid, which is the civil legal services program that covers a good portion of the state, so central and western Massachusetts. And we represent individual clients who have faced discrimination to help them enforce the rights. So we've talked a lot about the laws that are on the books and how comprehensive they can be. But we've also talked about how voucher holders are still facing pretty high rates of discrimination in the rental market. And so I'm here to talk a little bit about kind of the role of enforcing the laws and what that looks like. The Massachusetts legislature initially enacted protections against voucher discrimination all the way back in 1971. So over 50 years ago. And at the time, the statute simply said that housing providers, so landlords, real estate agents, couldn't discriminate against an applicant or renter solely because that individual received rental assistance in the form of a voucher. In 1987, a case that dealt with this new law, or a law that had been on the books for a little under 20 years, went up to Massachusetts highest court. And in that case, a landlord had refused to rent to a voucher holder on the grounds that the lease had burdensome terms in it. So the voucher program used a standard model lease, and all landlords had to use that lease when they rented to a voucher holder. And the landlord said, it's not that I have any bias against voucher holders. I don't think that they're worse tenants. I don't have any preconceived notions about them. I just don't like the lease. So the court looked at the law and said, okay, we don't think that's discriminatory. You're not refusing to rent to them solely because they received Section 8. You simply don't like the lease terms. And so based on that court decision, the legislature responded and said, no, that's not really what we wanted the impact to be. We really wanted to increase housing choice for voucher participants. And so that's when they changed the language to include a definition of discrimination that included not just bias-based discrimination, but refusals to give voucher holders housing opportunities because of any requirement of a voucher program. And Sophia had talked a little bit about some of those requirements, right? I mean, there can be a lease up process, there can be an inspection, there's paperwork. And the idea is you can't use any of those justifications to legitimize your unwillingness to kind of participate or grant a voucher holder a housing opportunity. And still since 1980, or since in the early 90s, when the legislature made those amendments, many tenants have had to go to court to even enforce those protections. In 2003, the state Superior Court upheld a finding that the Massachusetts Commission Against Discrimination made, that a landlord had engaged in discrimination on the when he said that it was frustrating to deal with the Section 8 program and didn't want to rent to a voucher holder. In 2007, another case went all the way to Massachusetts top court, rejecting a landlord's argument that it was based on economic concerns, that he might be losing money if he waited longer, or had to go through more hoops to terminate the tenancy of a voucher holder. So again, reaffirming, no, this is really what the statute means. But as Maureen mentioned at the beginning, Suffolk University did a study, or published the study in 2020, that showed, again, high rates of voucher-based discrimination in our rental markets. Sophia also had mentioned that the state participates in what's called moving to work, where the federal government gives the state some flexibility in really trying to promote housing choice for its residents. And so the state recently decided to use some of that money that it receives and fund enforcement measures. So again, that where tenants are able to actually realize the protections and promises of the fair housing laws. Right now, there's a group of agencies called the Fair Housing Alliance of Massachusetts, and it's comprised of some entities that have been doing fair housing work for decades, including the Housing Discrimination Testing Project of Suffolk University, the Massachusetts Fair Housing Center, the South Coast Fair Housing Center, and Community Legal Aid. So we applied for funding as a partnership to really bring enforcement resources to this field. Some of the activities that we engage in are collaborating with Snowmass and Sophia's program, so that when the barriers that folks are facing are discriminatory, there are resources that we can provide. We've engaged in outreach to local public housing authorities, who often have conversations with their voucher holders when their voucher holders are unable to lease up. And discrimination may be one of the barriers that they're facing. We are doing statewide testing and investigations of discriminatory practices and filing enforcement actions based on the results of those investigations. And then again, we're providing direct legal assistance to individual households. As John mentioned, discrimination can take a variety of forms. So it can be when a household is looking for housing most often, is again, the no callbacks, that just, we don't want to take the voucher, maybe inaccurate information about the ongoing availability of the unit, saying it's gone already when we know it, perhaps it's not. But we've also encountered situations increasingly where tenants are being displaced because they are voucher holders. And so my agency is currently representing a group of 8 tenants who reside in a variety of different buildings across Western Massachusetts. An out-of-state investor bought their apartment buildings in 2020. And basically came to the conclusion that, and they bought the buildings with the intent of renovating them and increasing rents, right? So it's pretty kind of a classic story. I think as they worked with the tenants there, they came to the decision that like it was too frustrating to try to raise the rents of the voucher holders. They misunderstood the voucher programs and thought they could never be able to get the rents that they might want. They thought the process took too long. And so they targeted the voucher holders for eviction. And so we were able to kind of connect with those families in the eviction process and determine that they had been selected for displacement or eviction because of their vouchers. And so we are currently litigating those cases to attempt to, again, give those families the same opportunities that other folks that lived in those apartment complexes got, which was an offer of a new lease, the ability to negotiate a new rent, right? It's literally just that they be offered that opportunity. The vast majority of those tenants weren't even offered the opportunity to have those conversations with the new landlord. Some of those tenants came and said, let us know what you want us to pay and we will, and let's see where we can go. And the investor wasn't interested in that. So at the end of this presentation, there's a resource slide. This initiative to kind of increase the resources for enforcement of violations of the state protections for voucher holders is statewide. So really kind of any household with a voucher that's facing illegal barriers should reach out either by phone or other contact information on our website to get connected to legal resources so that we can counsel people about kind of what their best options may be. And then I think we'll take questions at the end. There's a question now about how we made the connection between all the voucher holders in the eviction case. Is that the question, Katie? I'm trying to remember. I think we caught them in stages. It happened in phases. So they came in pairs kind of. And some of them had been in conversation and heard, oh, like we think maybe the voucher holders are being targeted. And then we were able just to kind of like connect, pull them together, kind of monitor somewhat the eviction filings by that investor in the local housing court, once we kind of have an idea of a potential pattern. And then actually it was also a very close-knit community. So many of these tenants live next door to each other. Some of them have lived next door for 30 plus years in these communities. And so I think once one of them connected with us, they basically were talking to their friends and saying, you know, look, we've connected with some supports, and we were able to connect that way. But that's all I have for now. And so I think our next speaker is Todd from Greater Boston Legal Services, who can talk about his agency's efforts to enforce these protections.
Thank you so much, and good afternoon, everybody. It's really a delight to see everybody here, and I really am thankful for the foundation that the prior speakers provided here as to like the terrain, what's going on. And what I'm going to talk about is kind of our case, how we built it a little bit, and what are the claims and what's really going on here. But I want to step back and talk about, well, what's really this tenant screening that we're challenging is about. And it's about selling something to landlords, and usually large institutional landlords, I want to be clear, that is basically doing the kind of things that we've seen all along, which is trying to exclude low-income people and people with vouchers, but doing it wholesale, not retail. So what I mean by wholesale is developing criteria that categorically excludes people and is it's not disguised in some way. It's just kind of saying, I'm sorry, the score that this particular piece of software has created is the law. That's it. And their primary defense, not to jump to the end of my presentation, is that this is a neutral criteria. It's not intended to discriminate. It just happens to be that some people, you know, if you have a voucher and everything's perfect about you, you're going to get in. But as we know from our work with voucher holders and our work with tenants, the low-income people and persons of color are way, way more likely to have the kind of red flags like credit card debt or delinquencies on loans that are triggering these denials in this automated safe rent territory that we're challenging. So let me just step back and say, what is safe rent and how does it work? So safe rent sells itself as a automated system that generates a score, thumbs up, thumbs down, or maybe sometimes in the middle, maybe, but 99% of the time what people are buying is thumbs up or thumbs down. And they're using a large databases, and they're not really telling you how they weight the different criteria. You can get a report. In fact, I looked at one today from a tenant who was denied, and it tells you all of the things they looked at, but it doesn't tell you how they weighted them. And the most important, and let me just talk about, so credit card data, as I said, it looks at eviction records. In Massachusetts, it doesn't look at criminal records. And it looks at other things that are just kind of pretty opaque. You can't really tell what they're looking at. And most importantly, it does not tell you how it weights things. And I should say, even more importantly, it does not take into consideration your landlord reference. This is, let's be honest, this is crazy. Our clients, low-income clients with vouchers especially, they pay their rent. Why do they pay their rent? Because they have to keep a roof over their head. Do they sometimes let credit card debt go more often than other people? Yes, because they're focusing on keeping a roof over their head. They're focusing on keeping food on their tables. They're focusing on the essentials. And that is exactly what Safe Rent ignores. They ignore the fact that people are prioritizing the rent. They don't care about your current landlord. And they're ignoring the fact that with a voucher, your rent is by its very definition going to be affordable, and they're ignoring that. So that's kind of the big picture of what they're looking at, and I'll tell you a little bit about how we built our case. So we were seeing that just like you all, and I started saying, hey, I want to talk to people who have been denied tenancies. Now, usually we don't do that. We're focusing on like evictions, whatever, but we wanted to figure out what's going on in the field. So we talked to people and we figured out what was their experience. We looked at denials. And honestly, we're looking for good named plaintiffs. So this is a class action that represents all voucher holders and persons of color that are applying and denied housing with vouchers in Massachusetts. And it is a narrow class. By its nature, it's only look at voucher holders. And that's because we want to be very crystal clear that the use of criteria that's not legitimate to exclude people that are prioritizing their rent and have, by their very nature, their rent is affordable, that should be illegal. Now, next case, we'll go on to the next thing, but we're trying to start with what is everybody should agree with. And so that is the nature of our case. We found two individuals. One had been denied a new housing development, had some set aside units in Canton, and it was a 55 plus community. She had her current community where she was at had shootings. It was really a rough area. And this is where we talked earlier about housing opportunity. This is where the rubber hits the road. People are being denied the opportunity to go to places that are, are affordable by their nature. They fit within the payment standard, but they're being excluded by these artificial barriers. She was denied, and we worked with her to overcome that denial. But without our work, she would have been rejected, and she never would have got into that development. And we were kind of lucky in that regard because there was a affirmative action or a affordable fair housing officer at that organization that actually listened. But still, without us advocating, she would have just been left on the hitting a wall and not getting in. Another person was trying to move within Malden to another development. The one in Canton had a pool and tennis courts. I've been there. It's pretty nice, brand new. The one in Malden was not brand new, but it has a pool. It's kind of advertises itself. If you look at their website, it's almost looks like a gated community. And she wanted to go there for similar reasons, because the area that she was living in had a high crime rate, and she wanted to move to a nice place. It was affordable with a payment standard, and they, in contrast, they did not care. She had perfect landlord references. She was a security guard at a local university, and she still is. And she because she lost her second job, she had some credit card debt. I mean, that's what our clients' experiences. But she had always prioritized her rent, and she had 15 years of good landlord references they did not even care to look at. We also have an institutional plaintiff, the Community Action Agency of Somerville. They had a specific grant to place people with Section 8s in housing, because we all know if you don't place it within the search time, you're going to lose it. So this is an incredible opportunity for stabilize your family, have greater opportunity for your children, find good housing, and if they can't place it within a short period of time, they're going to lose that voucher. That's super valuable and could be life-changing. And so the Community Action Agency of Somerville is steering people away from these places, saying, let's focus on places where we know you're not going to be rejected, even though the illegal criteria was being used, and these people often had, great references, long-term tenancies, and had basically lucked out and gotten to the top of a wait list for vouchers. So I wanted to talk a little bit about where we are in this case and what their challenges. So we're at the motion to dismiss stage. So it's very early. We filed a complaint, amended complaint. We drew a very good, we hope, federal judge, Angel Kelly, who is a Biden appointee. We have great partners, the National Consumer Law Center and a small civil rights firm, Cohen Milstein, based in Washington. And they're both working on that, this case with us, pro bono. And at the motion to dismiss stage, here are things that they're trying to throw at us, which is that this is neutral criteria, and HUD and others are allowing this criteria, that credit screening is okay. And I think that in the past, you know, HUD has kind of, and other housing providers have said, yes, you can screen for credit. But I think the important overlay is that you can't screen for credit if it's going to have a discriminatory impact. And, you know, we're the first to admit that we are pushing the edge of the law. People have often said neutral criteria, legal, neutral criteria, legal. We're saying neutral criteria that has a discriminatory impact is not legal, especially, and this is what I've not said this explicitly, but especially where the criteria is bogus. There are no studies that show that that small amount of credit card debt that you ignored, that you didn't ignore, but you let go of because you were focused on keeping a roof over your family's head. There's no studies that say that that's a legitimate reason to deny somebody for housing, or that affects your future ability to pay rent. People say, oh, intuitively, perhaps that's their argument. It's like, oh, we use credit scoring for everything. We use credit, but those are credit scoring and credit, the use of credit history historically has only been studied in the use of extending credit, not rent. So they're jumping from one area to another. They're importing, if you will, criteria from another model into the tenant screening model, and they're saying that makes it legitimate. And we're saying that that kind of so-called neutral criteria, where there's no evidence that it is a legitimate indicator of future ability to pay rent, is not legitimate. And we're saying so as a discriminatory impact, not only on voucher holders, but on persons of color and that have a higher incidence of delinquent non-tenant credit. So that's basically categorically shoving them off the table and saying, sorry, we're going to move on to the people that, you know, oftentimes it's not going to be Section 8 voucher holders that they're going to. We also say that they're ignoring the value of the subsidy. So it is important to think about. We know that this pandemic is Exhibit A. When the pandemic hit, people lost their jobs. People with vouchers continued to pay their rent because housing authorities even went retroactive. I had a Section 8 tenant. I have one little unit in our house. She got a retroactive adjustment. People who have vouchers are, by their definition, have a greater ability to pay the rent because of the flexibility of the voucher, the way it compensates for what happens in normal people's lives. So to the extent that they're saying income and vouchers are equal, that's not true. Vouchers are more valuable as an indicator of your ability to pay rent than income alone. And that we explicitly say that in our complaint. And I think that's something that we're trying to flesh out and push on. I think it's important to think about defenses. What is the industry going to say about this? And they're already weighing in. And in fact, at the motion to dismiss stage, there's an industry amicus, and the Department of Justice and HUD have also put in a statement of interest, weighing in not on the merits of the case, but on the criteria that this judge should not dismiss this case at this stage because we have adequately pled a discriminatory impact theory and basis and enough facts to show that. But it's pretty amazing that the Department of Justice and HUD have weighed in at the motion to dismiss stage in a federal case. But let's think about some of the the possible defenses? Well, I already talked about neutral criteria, that all screening is subjective. So all screening is subjective. And as we know from mortgage lending underwriting, that the injection of subjective judgment means that you're also importing and you're bringing into the screening and underwriting process bias. So they're going to say, well, these are different evils, but this one at least is, you know, built and not going to allow the managers to bring in their own bias. And then I would say that landlord reference, they're going to also would likely attack landlord references. That landlords have, they will assert the landlords have a motivation to lie to get rid of their bad tenant. So, you know, then you say, well, go back to the prior landlord. I mean, there's subjects that we know that that landlords are not stupid, and if they don't trust, they don't think, oh, this landlord's telling the truth. They can just ask for, you know, prior landlord. I mean, or we can also think about the way that Mass Housing has laid out the model tenant selection plan, which is you don't go to credit screening unless there's no landlord reference, which just kind of makes sense that you should use the legitimate screening tools that we know are available, and only when you don't have adequate references go on to those other things. So I've used about my time. I did want to say on the slide, we have a slide at the end, or we're going to put in the chat or wherever, we have our link to our complaint, a link to our opposition to the motion to dismiss, and we have a link to the Department of Justice HUD statement of interest. And this is at its very beginning stages, but we are very excited about this and feel like it. Hopefully, this will move the needle a little bit in terms of trying to push the envelope on the law in this area.
Great, thank you, everybody. This was really lovely to hear sort of a wide range of perspectives and issues that folks are facing. I will share the slide now, and then while I'm doing that, if folks want to either sort of raise their hand, take themselves off mute, share a question, put it in the chat, you know, I think we can open this up as like more of a conversation at this point. This as a Of course, I'm like, I cannot remember where the PowerPoint slide is to make it full screen. Why can't I see it?
If you go to view, up at on the menu at the top, view.
Oh, it's because like, yeah, thanks.
Yeah, view right at the very top. Over to the right.
I can't get there because of the like.
The mouse doesn't want to cooperate.
Like, yeah, I can't. I have like the Zoom screen at the top that's like blocking me from getting to that somehow. Just move it to the side.
Minimize it, I think it'll bring it down.
Yeah, I got it. Okay. Here we go. Sorry about that, guys. And then where's the...
Go to
Or maybe slideshow.
yeah.
Where is it? Oh yeah, thank you.
I'm sorry, it's not view, it's slideshow. Yeah, I'm sorry.
Well, here we go. Okay. So we have two slides here, and I'll just like leave one up for a couple minutes and then switch to the other. The only problem that I did not foresee, and this is like, again, now you guys can see like my technical savvy is really strong, that I like am sharing my screen. So like for me to turn on the chat, I don't know if I can see the chat still. Oh, you guys are just telling me how to do it. Thank you, everybody. The only question that I see is one that Todd had sort of already answered, which is is it possible to prevent landlords or realtors from using a voucher holder's credit score to exclude them from an apartment? So if there's anything anyone wants to add to that, besides what Todd said, that would be great.
Well, I personally think that that's a legitimate basis to file an MCAD complaint. I don't know what other people think, but I believe that it's, we really should be pushing the envelope on this, because I think that it's not a, again, it has a discriminatory effect. What's the good business reason? I don't know what the good business reason is. Go talk to the person's landlord. Don't just use this credit score to shove people off the table and disregard their application. So I'd be curious to see what other panelists think about that.
Yeah, I mean, it's always like the frustrating lawyer response of like, it depends. But I think, I think it's Todd's theory in his Stay Front litigation is the theory that we use here, which is we think it's going to disproportionately impact people who have vouchers. It's likely to disproportionately people of color. And once you know that, right, the only real thing that can justify it is some business reason that is the only, and that this use of credit is the only way to accomplish that business reason. And I think, as Todd has said, there's very good, there's good arguments to be made that they don't have much to stand on. What is it going to take, possible to prevent? Unfortunately, right now, it might be something like, filing in federal court or filing in state court. That's where the enforcement comes in. And then, sometimes it's just education. I think in our office, when we face denials, we often do reach out to the landlord, the real estate agent, to really kind of push a little bit and see if we can kind of figure out what the concerns are and address them before going to court. But again, I think Todd has articulated the legal theory that would be used.
Hi, this is Katie again from, and I work at Metro Housing Boston. So we see, we administer vouchers and we see this all the time. And so a lot of times, I hear from voucher holders that they believe they're being discriminated against because they have a voucher. And, we talk about it. The ones that get to me, we talk about what some of their options are, and, a lot of times, filing a complaint, waiting a year and a half is not helpful because they need an apartment right now. I have had some success with referring cases, voucher holders to some of your organizations to get some of that intervention, that early intervention in the moment. Like, hey, listen, what you're saying may not be. It doesn't sound like it's actually kind of legal. But I was wondering if there was something. These cases don't always get to me, but a lot of our my staff may hear about it. And what can someone who is not an attorney say? Like, what can they do in the moment to let property owners know? You might want to look into that. You might want to, I don't know if that makes sense. A lot of, aside from legal intervention, well, not everyone's going to get. What kind of information can we give voucher holders or staff who administer vouchers? Just hope that makes more sense.
Yeah, I mean, I started talking, but I'm not sure I have the answer necessarily. But I think the question is really important because obviously, like, there's not enough of me's or Todd, right? To we can't just rely on kind of individual enforcement, which is why some of the snowmass programs are so important. And I think that's one example of what a non-attorney can do, is where the state has kind of tried to build in these educational structures, financial incentives. But again, I mean, we do have these conversations, kind of non-legal conversations with landlords sometimes, and say, it's, it sounds like your concern is, making sure the rent gets paid. Let me, good news. Let me educate you a little bit more about the voucher program. And, if there were ever going to be a tenant that had a stable ability to pay their rent, it's a voucher tenant, right? They could lose their job and the tenant's gonna, the rent's gonna get paid, things like that. So it sometimes that works, and sometimes it doesn't. And then unfortunately it comes down to enforcement. And you're right, like, it's not very appealing to voucher holders to say, I'm gonna go file an administrative complaint and maybe in a year or 3, something will happen. I guess I would say the more people do that, theoretically, the less often we're going to see discriminatory behavior.
Yeah, I try to encourage them, like, okay, well, after you get, especially if it's something that seems pretty blatant, I'll say, you're like, well, after you're all set and you're in your place, if you want to go back, if you want, you've 100 days, I tell them, and by that time, sometimes I even follow up, and they're like, nah, we don't want to do it.
I mean, when people, voucher holders, like the rest of us, are really like feeling the crunch of housing instability, right? And the fact that there's just not enough housing available right now. So people are willing to push, I think, a little bit more in the past, because like kind of they need a roof over their heads. Credit is hard because you're making a little bit more of a nuanced argument, but where we do have blatant discrimination, we have been able to run to court that day, the next day, when we have strong evidence, and get a court to like freeze the unit and not have it, not be rented to someone else to process the voucher holder. And that has been successful. I don't want to say we can do that in every case. We kind of have to have a smoking gun type of case, because it's a big lift for a judge to order a landlord to kind of pause what they're doing. But it can happen sometimes.
I'd just add, you can also get in touch with the Attorney General's office, and in appropriate cases, we can get in touch with the landlord to explain to them the consequences of what they're doing, and that can, particularly in the last 18 months or so, we've been having increasing success with getting landlords to simply lease up or to move along.
And John, how do we do that? I mean, how would we refer someone to you if I heard something that I thought sounded blatant?
Yeah, so the easiest thing to do is to file the online complaint, because those usually get channeled appropriately within a day or so. You can also, you can also email us directly. I'll just say we're fairly easy to find, all of the AGs that work in civil rights. And if you have any trouble finding our contact information, you can either ping Maureen or someone else, and they can distribute it. But the other thing I'd say is that, for the people who work for housing authorities and housing agencies, when you're hearing those reports, it would help us if you would pass it along, because again, as opposed to some of the other legal aid organizations, we don't need a plaintiff in order to bring these cases, and we don't need someone to even be willing to identify themselves, so much as just point us in the correct direction. So if there are caseworkers who are getting repeated complaints about particular properties, that's information that can be very helpful to us. And frankly, in the last 5 years, that's how we've built 2 of our largest cases, is not by individual tenants coming to us, but by people that work at housing authorities and housing advocacy groups getting in touch and telling us, look, we know that the people that we work with and the tenants and the families that we work with won't even apply at these properties because they know it's a waste of time. And that, like I said, that's simply pointing us in the right direction, can be quite helpful, because we can carry out an investigation from there, and bring cases where it's appropriate. Looks like there's a question about holding fees and application fees. So this is also something that we've been dealing with. There's two aspects to that. Massachusetts has a separate law about what can and cannot be collected as part of a housing application. And particularly with subsidized tenants, where it's generally unclear at the point at which someone's applying what their share of the rent may or may not be. Collecting fees to hold apartments in any amount before there's a rent determination is problematic and something that we want to hear about. And certainly charging application fees for anyone is not lawful in Massachusetts. So, one of the things that we look at is if a landlord is, there is potentially a distinction between an application fee and a rent deposit. But there are limits on how much you can collect in terms of a rent deposit, and a rent deposit, because it is a deposit towards rent, has to be refundable.
Any other questions that folks have?
Maureen, I did see a question about snowmass, so I would like to answer if I can. I'm
Oh,
sorry.
thanks. I missed that.
That's
Yeah.
okay. The
Is it
question
reaching
is,
out? Is
Yes.
Snowmass reaching out to landlords proactively? And is there a website that can be plugged here?
So the mobility specialists at each regional administrating agency, they are working with the family and the landlord as well. So they are part of the process. It's a collaborative effort. So oftentimes when the tenant reaches out to inquire about the unit, schedule a showing, the mobility specialists will follow up with a call. Oftentimes can be, at a showing if they go with the participant to see the unit. It depends on the circumstances. They will discuss with the landlord how the program works, number one, how Section 8 works, number two. Sometimes landlords may not know the process. They will walk them step by step to what the process is. And oftentimes, from what we hear, questions about holding fees, for instance, or about last month's rent. That's another thing with housing programs, last month's rent, or other questions that they may constitute discrimination. Mobility specialists can clarify. Again, they're not legal advocates, so they don't provide legal advice, but they can clarify that, holding fees cannot be paid because of this and this reason. Now, if there are questions that they are more to the participants, let's say income or more like confidential information, obviously we're binded by confidentiality. It would not be something the mobility specialist can answer, but obviously they can work with the participant, the prospective tenant on this, the landlord and the prospective tenant, and if the tenant feels comfortable answering. On the other hand, if there is a straightforward, if I can use that term, case of, discrimination, a flag like, no, you're not accepted, oftentimes the mobility specialist will provide the resources similar to the resources we shared a few minutes ago to the local legal aid agencies for participants to seek legal assistance. I hope I covered the question, but I'm happy to do a follow-up answer if needed.
Okay, if there are no other questions, we'll make sure that the slides at the end are available to folks, I think on the website after this. So if you weren't able to pull any links, or you still have, you want to have a copy of it, that will be available for folks to review later. I just want to thank all the panelists for their time today, and thank all of you for spending this lovely day outside with us inside on Zoom. So with that, take care and enjoy the rest of your day, folks.
Thank you.